All right, good afternoon. Welcome to the Criminal Justice Full. We are so happy you are here. It is March the 14th, and I'll be glad when supper time gets here. We call it personal orders. Are there any personal orders? So, welcoming and honoring. How's that?
Anything, Chairman.
Yes, Leader.
Mr. Chairman, it is from my understanding Pi Day, and I'm wondering if any members know how many digits are in pi. 3.14 is what we ordinarily have a shortened version of, and we have nuclear scientists and learned members that have been around for a long time and educators. I'm curious if anyone knows how many digits in pi. Mr. Chairman, call on anybody you'd like.
Right down here with this chairman.
Infinity.
Mr. Chairman, I believe we have a winner, and that is the beauty of pi. So on Pi Day, I'm going to go with the learned chairman on his answer. I can see Representative Fritz down here is chomping at the bit to jump into this riveting debate, but I just thought I'd throw it out there on Pi Day. Thank you, Mr. Chairman.
Yeah, I was thinking about something with a crust, but I feel better about that. Who? Towns. Yes, sir. Representative Towns.
Mr. Chairman, I beg to differ with the chairman. I think you're right. If you got 10 members in your family and you got one pie, it's 10 digits in that pie.
There you go. There you go.
Ain't no damn infinity. If you got 11 members, there's 11 digits in that pie.
Is it pumpkin pie?
Any kind of pie. It's called any pie.
All right.
Thank you,
Okay, Madam Clerk, will you take the roll, please?
Representatives Campbell, Carringer, Davis, Doggett, Farmer, Fritz, Glenn, Hardaway, Howell, Johnson, Lamberth, Moody, Russell, Sherrill, Towns, Vice Chairman Gillespie, Chairman Halsey.
Here.
Mr. Chairman, you have a quorum.
All right, thank you. First up today is House Bill 0794 by Chair Lady Hazelwood. You have a motion and a second, and you are recognized.
Thank you, Mr. Chairman. Just some background. This is this bill regards the Electronic Monitoring Indigency Fund. It was originally created to pay for the cost of ignition interlock devices for those that were deemed indigent by the courts. And over time, the scope expanded to include non-ignition interlock devices such as transdermal GPS. In 2019, the fund was divided into two accounts. One was set up for interlock devices, one for non-interlock. And the latter, when it was set up in 2019, the assumption was that the excess funds from the former would cover the cost. That has not happened. So there are no fees presently going into the non-interlocked account, and since there was no surplus as intended, so actually in fact, nearly every year we've had to include in the budget additional non-recurring state funding to supplement that fund. It was $500,000 in 19, $2.25 million in 20, $3.25 million in 2021, $2.55 million in 2023, and $2.6 million in this year's budget. So you can see it's trending in the wrong direction. So in an effort to address this, last year the General Assembly passed legislation that would create an electronic monitoring industry task force to study and make recommendations. And that was a real working task force. We had a number of meetings over the summer with lots of players who are involved in this field. We were charged with reviewing the current definition of indigency to make sure that only people who should have access to the funds were actually using it, and to look at possible changes and options for sustaining the funding and operation of the EMIF. So again, we met over the summer. We worked with the Department of Safety and the Treasurer to review current practices and procedures, and the final report from the committee was issued in 2022. There were a number of recommendations from that report. That's what's included in this bill, and it's actually the amendment makes the bill drafting code 4831, which I hope you have.
That's what I have. Is there a motion and a second on the amendment? A motion? A second on the amendment. We're voting on amendment 4831. All those in favor say aye. Aye. Any opposed? No. All right, the amendment goes on. Is there any other explanation?
Just, I'll tell you that the things that it changes, that the amendment changes in the operation of the funds, we're going to delve a little deeper into determining how indigency is determined. There's some more guidelines put around that. I can go through those as much or as little as you like. One of the big changes that even if you're declared indigent, we felt it was important on that task force that those who were accessing this fund, it's a benefit to them both to be able to access the fund and to be able to use the interlock device and to continue driving and all that. We thought that they should have some skin in the game. So everybody, even indigent or not, the minimum that you would pay is $1 a day or $30 a month for that interlock device. We also set up 2 separate accounts to be managed by the state treasurer, one for the ignition interlock and the other for non-ignition interlock devices. Local governments currently participate in the non-interlock monitoring device account by having the cost for eligible devices paid from the fund from each local government's indigent dependents fund. And under the bill as amended, there will still be 2 separate funds for investment purposes, but the non-ignition interlock portion will be administered as a grant program because we know, there's no money coming in to fund it. So it's simply going to be a grant program that would be administered by the Office of Criminal Justice within the Department of F&A. So again, and this would take effect on October 2023, October 1, 2023, and would apply to claims for alternative devices that are eligible for payment or pending an eligibility determination. And I neglected to say while we changed the funding in terms of the requirement for indigents to pay up to $30 a month, the total cost paid to the device provider is still capped at $200.
Okay, thank you. Any questions for the sponsor? Was that okay, Representative Hardaway.
Thank you, Chairman Halsey. First of all, Chair Lady, I love your bill. So my questions are not designed to derail your
Then just
bill.
call for the question and let's go on.
Well, he did call for my question. So, but you mentioned OCJ, and I've always had interesting conversations with them. When you say administrate, what will their role be?
Within the Department of Finance Administration, they'll be administering the fund for investment purposes. So you'll have, these funds will be invested in order to make
Okay.
money to the grants from.
All right, gotcha. All right, thank you, ma'am. Thank you, Chairman.
Any other questions for the sponsor? If not, we're voting on House Bill 0794. All those in favor say aye. Aye. All opposed, no. The ayes have it. Chair Lady, it goes to a committee you're very familiar with. It goes to Finance.
Thank you very much.
All right, next we're on House Bill 1253 by Chairman Crawford. You have a motion and a second. Chairman, you're recognized.
Thank you, Mr. Chairman. Thank you, committee. I got a chance to speak to this bill in sub, and so it may be a little redundant for some of you, but this bill, under current law, allows for witnesses of the state who is deemed necessary to come and testify in court that live more than 5 miles away. They can request witness expenses, and that includes travel and board. This fund is set up under the Department of Corrections, and the statute is TCA 40-25-129, so it's already put in place. We already have money in there to do this. We had some confusion whether these witnesses, some who were not able to pay the money to do the travel and to come testify, and so there was some confusion about whether these individuals could be paid beforehand or after expenses. And so we passed a bill last year, House Bill 2165, with the ultimate goal of hoping that that would straighten that out. And it did fix a lot of the problems, but we're still having some confusion there. So I'm bringing this bill to do away with that confusion and make it a little bit more clear that the witnesses' expenses can be paid up front to help with their cost of getting to the courts. Basically, what this bill does is it goes into TCA 4025-129 under C1 and takes the word immediately out and changes the word from may to shall. So this will allow the Department of Correction and district attorneys to work together. For those that are not able to pay those expenses to get to the court cases, they can get that money up front. If they don't have to have that, then they can, turn in a request of what they spent to be reimbursed.
Okay, thank you, Chairman. I'm showing an amendment traveling with this, 4959.
4959.
Okay, we need to put the amendment on the boil. Motion, a second on amendment. We're voting on amendment 4959. All those in favor say aye. Aye. All opposed, no. Ayes have it. The amendment's on the bill. Is there any other explanation that go with the amendment?
No, the amendment only shows that it takes the word immediately out and changes the word to shall.
Okay, any questions for the sponsor? Question been called on the bill. We're voting on House Bill 1253. All those in favor say aye. Aye. All opposed, no. Ayes have it. Thank you, Chairman. It goes to calendar
Thank you,
rules.
Mr. Chairman. Thank you, committee.
Next is House Bill 0554 by Chair Lady Littleton. You have a motion and a second. You're recognized. I think you have two amendments, one you're not taking and one you are.
Yes, I'm taking 5044.
5044, there's a motion and a second on the amendment. All those in favor of Amendment 5044 say aye. Aye. All opposed, no. The amendment's on the bill. Please explain.
This requires each district attorney general to designate at least one assistant district attorney general currently employed within the judicial district as the lead prosecutor in cases involving crimes committed against children when they can. Requires the Tennessee Bureau of Investigation, District Attorneys General Conference, and other relative parties at the request of the District Attorneys General Conference to work in conjunction to provide annual training to the District Attorneys General Conference or other appropriate staff members in the prosecution of crimes committed against children.
Okay,
So it does.
that's the bill and the amendment. Are there questions for the sponsor? Questions been called on the bill. We're voting on House Bill 0554. All those in favor say aye. Aye. All opposed, no. Ayes have it. Congratulations. It moves to calendar and rules.
Thank you, Mr. Chairman and committee.
All right. We are on item number 4 on your calendar. That is House Bill 0612 by Chairman Hawk. There's a motion and a second. Chairman, you are recognized.
Thank you, Chairman, members. House Bill 612 clarifies a provision that was recently added to code through last year's Public Chapter 399. It will state that the AOC, the Administrative Office of the Courts, is responsible for payment of determination of whether a defendant is intellectually disabled under TCA 39-13-203. It will be absorbed through the Indigent Defense Fund. In a nutshell, that's what it is, Chairman and members.
Thank you. That's the explanation. Are there questions for the sponsor? Representative Hardaway.
Thank you, Chairman, and good afternoon to you.
Hello.
Rep. So the only thing we're doing is designating where the money is going to come from in order to pay the bills.
Yes, sir.
Yes, Chairman. That, Representative Hardaway, that is correct.
All right, I thank you for it.
Any other questions for the sponsor? Question being called on the bill. We're voting on House Bill 0612. All those in favor say aye. Aye. All opposed, no. Ayes have it. Chairman, it goes to finance.
Thank you, Chairman. I was hoping to get involved in the pie conversation.
Yeah, me
there.
too.
Thank you, Chairman, members.
All right, we're up to item number 5, which is House Bill 1193 by Chairman Williams. Do you see that? I didn't see that. Yeah, you're exactly right.
Gant's here, though.
Is he on the bill?
No, but he's got his next bill off.
All right. We will roll a couple of spaces Okay, we'll roll that bill to the Hill. We are now going to roll number 6, House Bill 1198 to the Hill. We're now on item number 7, which is House Bill 0587. You have a motion and a second. And Representative Gant, you are recognized.
Thank you, Mr. Chairman and committee. This is concerning our DUI laws here in the state, and it is currently an offense to operate a motor vehicle if the person's blood alcohol concentration is 0.08% or more. Upon conviction for a first offense, an individual must be sentenced to at least 2 consecutive days in the county jail, no more than 11 months, 29 days. Anyone convicted of a DUI for the first time with a BAC of 0.20 or more must be sentenced to at least 7 consecutive days rather than at least 2 days in the county jail. The proposed legislation revises the minimum BAC for these enhancement purposes from the current 0.20% to 0.15%. This means that the DUI offenders whose BAC level is between 0.15% and 0.19% will now be subject to the enhanced penalty that I just described. With that, Mr. Chairman, I turn it back to you and for passage.
Okay, you've heard the explanation of the bill. Any questions for the sponsor? Question's been called. We're voting on House Bill 0587. All those in favor say aye. Aye. All opposed, no. Ayes have it. It goes on to finance. Congratulations.
Thank you, Chairman and committee.
We're going to go out of order and go back to item number 5, which is House Bill 1193 by Chairman Williams. You got a motion and a second? Chairman Williams, we're moving right along. We have missed you. You were recognized.
Yes, sir. I am still running behind all day. Yeah. Thank you, Chairman and members. House Bill 1193 was brought to me by the Jewish Federations of Tennessee. This bill, as drafted, would broaden the offense of desecration of a house of worship by changing the culpable mental state from intentionally to knowingly or recklessly. As the body knows, last year we spent $500,000 protecting synagogues across the state and hardening them and helping pay for security. What this would do is if they caught someone in the act, that they could charge them for the crime in which they were fixing to do as it relates to anti-Semitism across the state. Happy to answer any questions the members might have.
All right, any question for the sponsor? Yes, sir, Representative Towns.
Obviously, it's a good bill, but it's for not just Jewish synagogues, right? It's for...
Yes.
Okay, there you go. Thank you. Love to sign on to that bill.
Any other questions for the sponsor? Yes, sir, Representative Hardaway.
Thank you, Chairman. And maybe we have to go on a session to legal, but I'm interested in knowing what the legal difference is between reckless and intentional. So either legal or the leader. I'll take either one.
Would you like to answer that? All right, we're going to go out of session for a moment. All right, legal.
Michelle Fogarty, Legal Services. Intentional is defined as referring to a person who acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowing is the culpable mental state that refers to a person who acts knowingly with respect to their conduct or to circumstances surrounding the conduct. When the person is aware of the nature of the conduct or that these circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. And reckless refers to a person who acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all of the circumstances as viewed from the accused person's standpoint.
Okay, any questions for legal?
No, sir. Thank you, ma'am.
All right, we're back on the bill. Questions been called on the bill, House Bill 1193. All those in favor say aye. All opposed, no. Bill passes and goes to calendar and rules. And Chairman, you're recognized on the next bill, House Bill 1198. There's a motion and a second. You're recognized on the bill.
Thank you, Chairman and members. Just as a matter of giving you a little context, late last summer, in my district, a young family was traveling from Livingston to Cookeville for dinner. On their way, it was a father, mother, small child in the back seat, and the mother was pregnant with child. She was scheduled to have a C-section 2 days later after being hit head-on in my district by someone on their, which would have been their fourth DUI offense, driving someone else's car in their family that they gave it to them. What this bill would do, and it's named after the unborn child of the Flats named Silas Gable Flatt. What this bill would do is if you knowingly provide a vehicle to someone whom you know is impaired or intoxicated, then you yourself would be charged as an accessory for that, and based upon the number of DUIs they previously had. So, for instance, if my son, who was on his third DUI, took my car without my permission and I didn't report it stolen, or if I gave him the keys to the car and he did what happened in the case of this, then in that instance, then I would have to serve 7 consecutive days in jail.
All right, you've heard an explanation of the bill. Any question for the sponsor? Representative Hardaway.
Thank you, Chairman, and thank you for the bill's sponsor. Will this criminal liability, will it also establish civil liability? The costs, medical costs, and time off from work, and things of that nature?
That is not described in this bill. The only difference is based upon the number of DUIs the person who was driving had prior to, that it would be a graduated difference. So, for instance, with a first offense, meaning if in the example I gave earlier, if my son had a first offense DUI and he took my car or I gave him the keys to the car, then I would have to do 48 hours in jail. If it was the second offense, it'd be 72 hours. And for the third or however many number of offenses after that, it'd be 7 days in jail. As you know from serving in this committee and in the General Assembly, those who tend to break the law know the law as good as anybody does. In this instance, what we're trying to do is to prevent people from getting in automobiles impaired so that they don't take the lives of other people. And if a parent knows that they could be liable for the actions of their child, the chances of them allowing them to take their vehicle is dramatically reduced, and that's what we hope to do with this bill.
Well, thank you for the bill, and I'm pretty sure it's going to work on some folk. Mm-hmm. And I really believe if we're not establishing a civil liability link, that I would certainly support that in the future. Mm-hmm. Thank you, sir.
Representative Towns.
I would hope that if passed, that we could have some kind of PSA announcements on this thing where parents know, because we passed tons of laws. People don't know these new laws. And ignorance of it is no excuse, but still, I think it'd be a greater deterrent if parents or other individuals knew that this is going to happen to you if you aiding and abetting by giving over your keys or what have you. It's just my 2 cents.
Representative Glenn.
Thank you, Mr. Chair. Using your same example, what crime would you be charged with if you gave your child using your example, what crime would you be charged with?
Misdemeanor.
Thank you, Mr. Chair.
Okay, question's been called on the bill. We're voting on House Bill 1198. All those in favor say aye. Aye. All opposed, no. Ayes have it. Chairman, you're going to calendar and rules. Yes, sir.
Moment of personal privilege. I recognize I'm not on the committee, but I do want to take an opportunity because I think that's really important for people to know. When these kind of things happen in our communities, we pick up the phone. The first person we call are people like Michelle Fogarty, and she helps us try to figure out a better way to protect our communities there. And so I think a lot of times, being a dumb contractor like me, I don't really know a lot about the law, but Michelle's been fantastic to work with, and she helped me kind of sort through this a little bit so we could protect the family. But so I want to say thank you to Michelle and all of our
Good to hear. Would you like to say a word? All right, we're up to item number 8 on the calendar. It's House Bill 0159 by Representative Capley. You have a motion and a second. Representative, you're recognized.
Thank you, Mr. Chairman and committee. This is a pretty simple bill. This exempts the possession of carrying a pocket knife by a non-student adult from the offense of possessing or carrying a weapon on school property if the knife remains concealed at all times while the adult is on school property for the sole purpose of voting in an election for which it is their designated polling place. And that's all I got, Mr. Chairman.
All right, thank you, Representative. Questions for the sponsor? Leader.
Thank you for bringing this bill, and we want to make sure you had a little snack there. It's late in the day. Yep, just feel free to put that in your pocket. It's all good. So we like to take care of our freshmen here. I do want to say on a serious note, I feel like this remedies an issue in the law that folks probably violate thousands of times throughout the state. You know, adult walks into a polling location, they don't even realize, okay, well, this is in a school. Well, they're committing a felony. And, you know, it's rarely ever prosecuted. I can't imagine any district attorney that would bring a charge on something like this. But at the same time, we don't need to have something like that on the books where if it's not being operated as a school, it's a polling location at the time, and somebody happens to have their pocket knife on them, that shouldn't be a crime. So thank you for bringing this. I really appreciate it. I hope it's something everybody can get behind.
All right, any other questions for the sponsor? Representative Hardaway.
Thank you, Chairman. Sponsor, you going to share them Cheetos?
We need the definitions of knowingly again.
I guess we'll have to see how this vote goes, Mr. Chairman.
Let's see. Yeah. All right, any other questions? All right, question been called on the bill, House Bill 0159. All those in favor say aye. Aye. All opposed, no. Ayes have it. Take your pocketbook or your pocketbook and your pocket knife, and we'll see you. You're going to calendar and rules.
Thank you, Mr. Chairman of the committee.
All right, we're up to item number 9, which is House Bill 0806 by Leader Lambert. Motion second. You're recognized.
Thank you,
Leader.
Mr. Chairman. I have an amendment that adds on to the bill. It's amendment coded 4943. Thank you, sir.
Amendment 4943. Let's get a motion and a second. Motion. All right, we're voting on Amendment 4943. All those in favor say aye.
Aye.
All opposed, no. The amendment is on the bill. Go ahead, Leader.
Thank you, Mr. Chairman. And again, this is the RICO bill that we have discussed several different years in a row. We have worked on this to try to make sure that we go after just the worst of the worst, and we do not in any way, and that's what some of the amendment does. It clarifies we don't want to go after someone who has isolated criminal behavior or there are punishments for that if you a one-off criminal offense. But when it's a collective offense where you've got an organized crime that's coming together, those are much, much more serious crimes, and they create a nexus in a community where hundreds of other crimes, quite frankly, reverberate out from that. And so with that, Mr. Chairman, I stand ready for questions.
All right, any questions for the sponsor? Representative Hardaway.
Thank you, Chairman. And to the leader, I appreciate the bill because as you and I have talked about numerous times about how do we address the criminal gang activity that's devastating our communities. And if you would just comment briefly on how this helps.
Yes, sir. And say the first part of that again. We were discussing reverberate or reverberate over here. And so we were having a riveting conversation about the proper pronunciation of some of the language that I had used. Chairman Moody of Education said it's reverberate. So if you can repeat your question.
Leader, to try to get an idea from you on how this helps us to attack the criminal gang activity that's devastating our communities.
Yes, sir, and on a serious note, and thank you for that question. The charges that are listed here are very specific, and these are charges that we see that are utilized in gang activity, in organized crime, in some of the stuff that you'll see in third world countries overseas, where you have a nexus of individuals that are committing crimes together. It is a common scheme. It is an organized criminal activity. I mean, think the mob from back in the day. I mean, those type of things. This is what this will be utilized for, and the only thing it can be utilized for, because it's a very high bar. It's very difficult to make these cases. The few cases that I've seen on this type of thing, both at the state or federal level, one, they're rare, but two, they take years sometimes for an entire team of prosecutors to work on to try to bring these cases and draw all this together so that they actually can prove beyond a reasonable doubt, because that is what is required with this. If any tiny little part of this is not proven, then it all falls apart and these individuals would not be convicted. And so the way this helps is it will go after those masterminds of criminal activity that are out there that are really at the center of a web of criminal conspiracies that spread out through an entire community. And if you can go at the center of that, you can do an enormous amount of good in trying to stop folks from just poisoning their communities, quite frankly, with criminal activity.
Once again, I thank you for it, and criminal gangs need to be on notice. Here comes justice.
Okay, Chair Lady Moody, your name was called. Do you have a response that doesn't reverberate?
Well, since my name was called, it was called this morning, and I didn't get a chance to respond.
Oh yeah.
And so I just, for the record, I have never seen Chairman Halsey's bathtub.
Yeah,
So,
statute of limitations up on that. All right, Vice Chair Gillespie.
Thank you, Mr. Chair. I wanted to call the question.
Question's been called on the bill. We're voting on House Bill 0806. All those in favor say aye. All opposed, no. Ayes have it. Moves on to Finance. Leader. All right, I've got to transfer the gavel to Vice Chair Gillespie.
All right. Thank you, Mr. Chairman. Next up, we have House Bill 1475 by Chairman Halsey. Second. Mr. Chairman, you are recognized.
Thank you, Chairman.
And, we do have an amendment, too, before we...
We do. It's 4976 is what I have.
That is what I have, too, sir. All right. All those in favor of adding Amendment 4976 to the bill, say aye. All against? All right, the ayes have it. It is added. Chairman, you are recognized.
Thank you. Officers in my old department and some in that end of the state police I've talked to talk about an uptick in people who are running from the police in vehicles and fail to yield for the stop. There's two kinds of those. You have a Class E felony of evading arrest if there's no injuries or no endangerment. Then you've got a Class D felony if it creates a risk of death or injury to innocent bystanders. Each one of those have a minimum of jail time, and this increases the Class E side from 30 days mandatory in jail to 90 days, and it increases the Class D felony from 60 days in jail to 120 days in jail, and that's what the bill does.
All right, thank you for that explanation. Are there any questions? Representative Towns?
Thank you. Mr. Chairman, am I to understand that running from the police under either situation is still a felony if done so in a car, correct?
That is correct.
Okay, thank you, sir.
Anyone else? Representative Fritz?
Thank you, Mr. Chairman. Just one quick question. Any input from the jails as to far as what this is going to do to population, what we expect the impact to be?
I think that's in the physical note here somewhere. According to what the physical note says, it would increase on the Class D side across the state an additional 102.08 days in jail.
All right. Any other questions? Oh, Representative Hardaway?
Thank you. Did we, in our discussions, was this about vehicles, autos, or was this about by foot?
This is only vehicles.
All right. Thank you, sir.
All right. Chairman Russell.
Thank you, Chairman. I just want to say thank you to the sponsor for bringing this legislation about. I think the most dangerous things that we've got on the streets is vehicle pursuits, and hopefully this will persuade those that are going to flee not to flee. So thank you.
And I wanted to echo that statement too. So thank you again. I said that in subcommittee, but thank you. Any other questions? All right, we are going to vote on House Bill 1475. All those in favor say aye. Aye. All those against? The ayes have it. You are headed to Finance, sir.
Thank you.
You've got another one here, House Bill 1482 by Chairman Halsey. Chairman Halsey, you are recognized.
Thank you, Vice Chair, and thank you, Committee. House Bill 1482 deals with bail agents. Every year they have to go through training, and they haven't increased the fee, which is by statute. They haven't increased that since 1996. And so this bill increases the cap. Doesn't necessarily mean it has to be that much, but it increases the cap up to $450 for the block of training that they have to go through. Also, the bill and the amendment addresses some of this. It requires a bail agent to have a criminal history background check done once a year. And the bill says the individual is responsible for paying. That's $37.15 right now. And also, the bill specifies that the clerk who runs the criminal history will inform the association whether the bail agent is qualified to go to the next year's training, is how this amendment
All right.
reads.
And before we go any further, we're going to go ahead and roll both of those amendments and to adopt each amendment 4978 and 5656 into. We're going to vote on the first one first. All those in favor, say aye. Aye. All those against? The ayes have it. Now we're going to go vote on the second amendment, 5656. All those in favor?
Aye.
Motion a second, sorry. Now we're going to vote. All those in favor, say aye. All those against? The ayes have it. And now we're going to roll those amendments into one. Okay. Yes. All right, Mr. Chairman, back to your bill, sir.
Well, that's
it?
That's it.
All right. Any questions? Oh, can you withdraw that? Chairman Russell?
I just had a question, what the bonding companies think about it.
That's who brought me the bill, was the bail agency, yes.
Thank you.
All right. Any other questions? Seeing none, we ready to vote. All those in favor for House Bill 1482, say aye. Aye. All those against? All right, the ayes have it. You are headed to finance, sir. Thank you so much.
Thank you. You might as well close this out if you
All
want to.
right, with seeing no other business, motion to adjourn. We are adjourned.
Thank you.